Welcome to another episode of Regulatory Oversight, a podcast that provides expert perspective on regulatory enforcement trends. I'm Stephen Peepgrass, one of the hosts of the podcast. I'm also the leader of Troutman Pepper Locke's Regulatory Investigation, Strategy, and Enforcement, or RISE, practice group. This podcast features insights from members of the RISE group, including its nationally ranked state attorneys general practice, as well as guest commentary from business leaders, regulatory experts, and current and former government officials. We cover a wide range of topics affecting businesses that operate in highly regulated areas. I want to remind our listeners, if you enjoy our podcast, please visit and subscribe to our blog at regulatoryoversight.com. Our blog and podcast are great ways to stay up to date on regulatory changes across the country. Today, my colleague Jeff Johnson is joined by Mississippi Solicitor General Scott Stewart and Tennessee Solicitor General Matt Rice to discuss the scope of their duties, what inspired each of them to pursue careers in public service, and hot-button administrative law topics like the Chevron doctrine. By way of introduction, Jeff Johnson is a member of our RISE practice group and is the former Deputy Solicitor General from the Missouri AG's office. In that role, Jeff provided practical guidance to elected officials, advised on consumer protection investigations, and represented the state of Missouri in appeals in critical litigation in federal and state courts. Solicitor General Scott Stewart was appointed to his position by Missouri AG Lynn Fitch in 2021. Scott is the state's lead advocate for appellate litigation. He directly handles appeals for the state, oversees the state's appellate litigation strategy, and facilitates the state's involvement in amicus curiae briefs. Scott has litigated and presented oral argument in the U.S. Supreme Court, in all regional federal courts of appeals, and in trial-level courts across the country. Prior to his current role, Scott served as a Deputy Assistant Attorney General in the U.S. Department of Justice and worked as a litigator in private practice. He's also served as a law clerk for Supreme Court Justice Clarence Thomas and for a circuit judge in the Ninth Circuit Court of Appeals. Solicitor General Matt Rice joined the Tennessee AG's office in 2022 as Special Assistant to the Solicitor General before stepping into the SG role in early 2024. As the state's chief appellate attorney, Matt manages all litigation in state and federal appeals courts and oversees all published opinions by Attorney General Jonathan Skrmetti. Before joining the AG's office, Matt worked in private practice, in between clerking for Supreme Court Justice Clarence Thomas and the Honorable Sandra Ikuda in the Ninth Circuit Court of Appeals. Scott, Matt, and Jeff, I want to thank you all for joining me today. I know we're all looking forward to your discussion.
Thank you, Stephen, for the warm introduction. This is the inaugural episode of a series highlighting some of the hardest working and brightest public servants there are, State Solicitors General. Scott and Matt, thank you both for being here. Before we get into any discussion, I'll provide the standard disclaimer that the views and observations expressed by the guests are their own. So, Solicitor General is a mysterious title, and like the 50 states, every Attorney General does things differently. What does being the Solicitor General mean for your states in particular?
To start it off, great to be with you, Jeff. Great to be with you, Matt. Thanks so much for having me. It is an honor to be the Solicitor General of a state. I'm grateful to be the Solicitor General of Mississippi. In short, at least in our state, and I think this is generally true, the Solicitor General is the state's lead advocate for appellate litigation. The way I like to think of it is every case that a state has is important, but whenever a case leaves a trial court, it becomes even more important because it becomes not just about the case, but about the precedent, the rule that's going to govern all these cases. And I think maybe a key insight behind having a Solicitor General is the idea that you want somebody really keyed in, experienced with appellate law, legal issues, and doing everything that can be done to adopt the precedential rules of law that are correct and that will best benefit the people of the state.
I would echo what Scott says. I think it's a tremendous benefit to any office to have a set of appellate specialists that not only can kind of provide a different view of the case. As you all know, oftentimes the trial lawyers get dialed in on the facts in that particular dispute. And sometimes it's valuable to have somebody with kind of a little bit more of a removed approach to the particular case and a little bit more focused on the legal principles underlying it. I think it's also valuable from a perspective of our offices are handling. I know our office has 13 to 20,000 active cases at any given moment. So we have a lot of issues that are being litigated by different folks in different divisions. And there's some value, I think, in having kind of a central repository where we get kind of insights into what legal issues are being raised so that we can provide some forms of consistency across the position that the state is taking in its vast litigation.
I think that makes a lot of sense. Certainly making sure that the state isn't saying one thing in one case and saying something completely different with, similar facts certainly could cause a problem for both the state and its citizens. Can you guys sort of describe what the day-to-day responsibilities you typically have outside of appearing in court for your respective states?
Sure. I put it in 3 buckets. I mean, the first is drafting and revising briefs, either from scratch or from other divisions, from colleagues within my own division. That's bucket 1. Bucket 2 is preparing for arguments. Arguments themselves, especially appellate ones, of course, tend to be short, but the preparation is not. And there's just a lot that goes into preparing for any kind of an appellate argument because they are so important. And then the last bucket, at least for me, is what I'll broadly call strategy and advice. That falls in a lot of areas, just strategy about possible litigation, strategy about getting ready for appeal, strategy about different things that the office wants to do on kind of a more policy level. So for us, at least in Mississippi, it's those 3 buckets, and it just kind of moves around depending. This year, for example, I'm about to present my 4th oral argument of the year. So it's been a very oral argument prep heavy year, but that just kind of is somewhat malleable, different, flexible, depending on what the needs of the state and the office are, which is, of course, one of the things that's exciting about it.
Yeah, the only thing I'll add to what kind of Scott laid out there was our office is also in charge of Attorney General opinions. So that's another kind of miscellaneous item that we're responsible for. I'd also say that a lot of the kind of advice bucket, I think we spend a lot of time dealing with multi-state litigation, multi-state amicus briefs, and providing advice to our attorney generals as to, is this a brief that Tennessee has an interest in joining? Is this a case that we have an interest in joining? I think that is also kind of a major role that takes up, frankly, more time than I'd like because there are a lot of those briefs going around. I'm still struggling between the 3 buckets, which I think are a good way to conceptualize our role. I oftentimes feel like, you can get caught up in one of those buckets, whether it's editing other people's work from within your office or whether it's providing advice. I feel like it's constantly eating into the time that I have to work on my own cases. It's been a constant struggle for me to kind of figure out how best to allocate my time and what is the best allocation that is best for the office.
And Matt, if I can drill down a little bit on the opinions portion of your job, I know that you're not unique in the sense that some of the other attorney general's offices, their state solicitor generals also have input and help craft opinions that legislators or other people's request. Our question for you is, what are the parameters of like who can request opinions and how often does that happen for your office?
Yeah, so for us, it has to be state officials in their official capacity. So it can't just be a state official who's curious about an issue. It has to be part of we only provide opinions to help them, I guess, further their duties as a state official. That leads to some broad requests because, as you can imagine, state legislators, they can draft legislation about pretty much anything. There's not much limit on what legislators can ask. We will not answer requests that are submitted at the behest of private individuals. It has to be for state purposes. About 10 years ago, our office was putting out almost 200 AG opinions a year. My predecessor got that number down in her last year to 11. We're trying to look for an in-between. It's a lot of work, and I think that the AG opinion process to me kind of highlights the importance of having a case or controversy, because I can't tell you how many times that we have drafted one of these opinions where we have an abstract question that is presented to us and then later regret either a certain sentence or a certain framing because it wasn't in the context of an actual dispute. It's very easy to kind of provide loose language in those that we later regret.
That's understandable. And the last question for you on this is, what kind of weight do state courts in Tennessee give the attorney general opinions if they're on closely related or on topic legal questions?
There's case law saying that they are persuasive to the extent, so I think to the extent they're persuaded by the AG opinion, it can help us. I'll say, though, that because of the things that I just mentioned about how a lot of these opinions are not asked in the context of a case or controversy, it's typically, if you're saying something that is, if it's not directly the opposite of what you said in the opinion, I usually don't think we get too hard of a time because they realize we're trying to do our best with, a limited scenario and provide advice outside of the context of a factual scenario.
You guys have these 3 different buckets, and sometimes extra special projects come in that you guys lend your hand in advice to. What's the best part of your job?
Getting to solve problems for the benefit of the public and the state. I mean, it's one of the biggest draws to a public service job like this. I mean, I had a very positive experience in private practice, and you can do a lot of good in private practice, but in public service, you're just consistently doing stuff to fight for the public, promote the public interest that you just can't do in private disputes as consistently and as to the same extent. And there seems to be particularly significant gratitude, certainly in Mississippi, in my experience, for how much people appreciate the work the office is doing. And that's quite rare or special.
Yeah, I'll echo that. I mean, I think a lot of my cases since I've been here have frankly been challenges to state laws that are designed to protect children. I have 2 young children myself, so it has been personally very gratifying to have the opportunity to kind of work on these laws, often bipartisan laws that are drafted to try to protect kids and impose certain age verification requirements and whatnot. And to get a victory on those cases and really feel like you're making a difference on that front, it's a good feeling.
And you guys are both very accomplished attorneys with you both clerked for great judges on the Ninth Circuit, for, I guess, the best originalist on the U.S. Supreme Court right now, Justice Thomas. What drew you guys to enter, either to return to private practice in Scott's case or to enter private practice for you, Matt?
So let's see. So I've finished clerking in 2016, and I've had public service jobs since then. Before that, I'd been private practice at firms, clerked, as you mentioned, Jeff. So it's been quite a stretch in public service. I guess part of the draw, at least to Mississippi specifically in my case, I'm not from Mississippi. When I got out of law school, I mostly lived or worked in Washington, D.C. or in Northern Virginia. But I'd always been drawn to the work of state solicitor general, state attorney general shops. They seem to be doing great work, really important work. And it seemed like a really interesting place to practice law. And kind of when I was closing up, I was in the first Trump administration. I served at the Department of Justice for all 4 years in D.C. at Main Justice. And I was looking for opportunities, and just the Mississippi job happened to open up. It was a very new position at that time. My boss, Attorney General Fitch, created the Solicitor General position, and I liked the idea of going down to a state that seemed like a really wonderful state to build out and help form what I hoped would be a high contributing, very helpful part of the Attorney General's office. So at least for me, in the most current job I've had for, I guess it's now just hit 4 years, that was the big draw, being able to contribute to a great state and a great office.
I would echo what Scott said. I mean, I think there's no better place in the country to go and have the opportunity to litigate kind of cutting edge issues, meaningful issues, and to take a real role. I enjoyed private practice. I had some great mentors in private practice and wouldn't trade that time, and learned a lot from a lot of people there. But I haven't had as much fun practicing law other than potentially clerking for Justice Thomas. Other than that experience, I think this has been by far the most enjoyment that I've gotten out of practicing, not only because of the kind of meaningful work that we get to do, the opportunities that we get. I'm from Tennessee. This was an opportunity for us to come home and to kind of serve my home state and hopefully help contribute to continuing to be a great place to live like it was when I grew up here.
And then, Matt, we have to ask, is it better arguing in front of the U.S. Supreme Court or playing for the New York Yankees?
I think it was a tremendous experience to get to argue, and that was a tremendous opportunity for me. I'm very grateful that General Scrimeti trusted me to handle the case. We obviously had an incredible team working on the case from the trial level all the way up. I didn't actually get involved until the Supreme Court proceedings, but luckily we had a great team, and my friend Whitney Hermendorfer was there with me every step of the way, poring over every sentence of the brief and trying to work up responses to questions. But I also benefited from the counsel of others like Scott, who had his own high-profile case at the court a few years ago, and I benefited from his guidance and mentorship about what to expect, how to prepare, how to handle the media attention, because I think it's very different to have clerked at the court and then to have to be the one who stands up and argues. It's a different spot to be in. So I benefited from that guidance and mentorship.
Speaking of big, important issues, it seems like the federal government is grabbing all the headlines these days and making all the news. Do you guys have any recent developments or highlights that you want to share coming out of, say, the Tennessee Attorney General's office?
Yes. We've had towards the end of the Biden administration, there were a lot of new rules and regulations that were promulgated that Tennessee, partnering with other states like Mississippi, played a hand in challenging. I think that probably the most visible one was the Title IX litigation that we were involved in. And we got that modification and attempted rewrite of Title IX vacated. And we're still fighting with over intervention and whatnot. But the federal government has decided not to defend that regulation. I think there's been a transition, obviously, with the new administration. There's been some kind of, I don't know if it's wind down or adjustment period where we were kind of on the aggression and now we're kind of figuring out where our cases stand with the change in administration and how those cases are going to proceed forward.
And Scott, what new items have come across in the Mississippi Attorney General's office or enforcement priorities that the office has announced?
I mean, a big lawsuit filed earlier this year was a challenge to the end of the last administration oil drilling ban. That's a big deal, of course, to Gulf states and to just the country at large. Matt covered a lot of the interesting transitional period. I was actually at DOJ during a transitional period, so I'm kind of like looking and appreciating what many of my friends are now going for as they try to both figure out the job, figure out what they inherited, figure out how exactly to do everything, all as their kind of different important jobs are being filled in the office. Bringing to a good close a lot of the high priority items from the last administration will, of course, be important. I think we're still seeing some of the opportunities we may have on just the regulatory front. We know just administrative law matters will continue to be so central, just given the reality of that's where most of the action is these days. I mean, it seems like it's really been a while since we've had big, comprehensive federal legislation. You think back to, EDPA in the 90s or the Affordable Care Act is, I guess we're now over a decade beyond that, Dodd-Frank, some of these things. So a lot of what's happened in the last couple of administrations are executive orders, rulemakings, different agency actions and we're already seeing, I think, quite quickly that that's where a lot of the action is, and the dust is still far from settled. But we're kind of getting involved as much as we can. We're not having to file suits, of course, at the rate we previously did, but the multi-state efforts that Matt mentioned earlier on the amicus front, continuing with our own cases and trying to land those are all kind of continuing priorities.
Excellent. Speaking of the shrinking federal leviathan at the moment, in recent years, the courts have been more agreeable to enforcing limits as to what federal agencies can do. And as Scott said, it's where all the action is at the moment, is in the administrative law context. I think it's fair to say that with West Virginia versus EPA, that solidified the major questions doctrine, Biden v. Nebraska, expanding on major questions, and Loper Bright ending Chevron deference to administrative agencies, that the law, is presenting a clear signal that federal agencies have to be more careful in how they exercise that power. And I know that your states were involved in, I think, every one of those cases, if I'm not mistaken. But I guess the question is, what do you think that federal courts now have to grapple with about how these doctrines interact going forward? And where do you think these interesting questions are going to be presented best?
I think all of this stuff is very interrelated, the changes that we're seeing in the administrative law space. You mentioned the major questions doctrine, and I think that touches on a few issues that are hot button administrative law issues right now, which is one, the demise of Chevron, and two, the non-delegation doctrine. And I think major questions is kind of at the intersection of those doctrines. And I think it stemmed ultimately, at least in a more robust form, from a prior lack of enforcement with respect to non-delegation and from the Chevron doctrine. I mean, I think part of the fiction of Chevron was that if you had statutory silence, that you could assume that that was an implicit delegation of authority for the agency to take certain action. The major questions doctrine was kind of an impediment to that. It was, we're not going to, in this subset of cases, we're not going to assume that Congress has given you this authority. Now, post-Chevron, I think it's more of a kind of statutory interpretation principle, and particularly if we get a more robust non-delegation doctrine, which, as we've alluded to, there's a non-delegation case that has been granted at the Supreme Court for the next term. I think that major questions will kind of ultimately recede and become more of a statutory interpretation principle and maybe not be as much at the forefront. moving forward if we get a more robust non-delegation doctrine in the next term, and with kind of the post-Loper Bright world in which we're not taking statutory silence to be an implicit delegation of authority. But I'm interested to hear any reactions from Scott on that.
Right. And just real quick to key everyone in, the case that was granted at the Supreme Court of the United States is this consumer research versus the FCC. And that's about the universal service fee, if I'm not mistaken, where the Fifth Circuit held that the statute actually didn't have any textual grant of authority to the FCC to impose the fee.
That's a good lead in. I thought Matt made very good points. And I think he's right that these points, doctrines, rules, principles, they all kind of lead in, they interact. And I mean, I guess something that I think about quite a bit, and this is something that's interesting in the consumer's research case, is with all this litigation lately, all this going on at the federal level, I think we're sort of shining a light little bit on how government works, perhaps for better or for worse. I mean, the consumer research thing is, I think the parties do suggest that it is a somewhat unique setup, but it's one of these things where an agency has a power that is, the argument is it's a taxing power, very much like a taxing power, which is a very potent power. Then you have another situation with a delegation or a subdelegation to a private entity. And it, at the very least, is kind of bringing to the forefront, hey, this is how things are working. How do we as a country feel about that? I mean, should things be stuck back with Congress or what? And I guess the way I kind of look at it is it reminds me of a lot of themes that you see in kind of some of the 10th Amendment cases in the 90s, the 2000s, some of the federalism cases from around that time, where a big theme seemed to be political accountability, making sure that the people who were responsible for making decisions could be identified as responsible and could be held accountable for those things. To me, those seem to be big themes in some of those cases back then. I think shedding a light on, who is making these decisions. Is this something Congress really did? Is this something that belongs to the agency? Because you can appreciate that there's something very attractive about handing off authority or suggesting that someone else has authority. And then if things go badly, you can just sort of say, hey, that's not me, it's them. But if things go well, you say, oh, look, that actually is me because I helped pass this law. So I guess I see a strong accountability theme. I see that running through Chevron. I see that running through the major questions cases. Non-delegation, that seems to be a pretty critical point. And if nothing else, I think it's helping this conversation about people understanding like, oh, we have this humongous government. What is this part doing? What is this part doing? Why is that line item on my telephone bill each month? Who's responsible for that? I mean, it's just good that people know.
Right. And so I think one of the things that seems to be animating all of these cases, I think also including Loper Bright, is, the lack of clear statements by Congress and perhaps questionable agency action that's going on. And, I think the things that at least the courts have been sort of grappling with is like, are these things, is silence really authority for the agency to fill in the blanks for what Congress wanted them to do? Or is it really just that Congress didn't think about it at all?
I think I'm interested to see how this consumer's research case plays out, because I do think there is and Scott and I have talked about this offline, there's a fundamental kind of administrability problem with the non-delegation doctrine. The court, I think the reason the doctrine has not been vigorously applied is because it's not the easiest place to draw a line as to, when exactly are they just filling in details and when are they themselves exercising the legislative power. I do expect that we will kind of have a more robust non-delegation doctrine moving forward, but how the court articulates that and how much guidance that it gives to lower courts about how to police that line between filling in the details and exercising legislative power is going to be interesting to see how that plays out.
And do we think that the major questions doctrine is more of a substantive canon of interpretation, that when we look at the statute and the agency says, oh, a system for emissions means this 500-page program that everyone has to do? Or is it more of a hard line, separation of powers? The executive shouldn't be going further than what Congress has said.
Well, I think this may bring in Justice Barrett's very thoughtful separate opinion in the Nebraska versus Biden case, where she kind of addresses this issue, and I think she does very well to pinpoint certainly the intuition that about the realities of how people use language and what their expectations would be. I think she uses some very nice examples about when you leave your kids with a babysitter and say, have a good time, the implication of how good or an elaborate a time you're suggesting, a full-blown multi-night trip to Disneyland versus pizza and dinner kind of a thing. And you're like, that's a really nice way to capture some things. I won't say that I have a completely settled view as to, which bucket it falls in. I do think that there's something to be said about strong clarity when an agency does want to take some big action. And West Virginia versus EPA is, I think, a very good example. I mean, nobody was suggesting that was a small issue there, and the court seemed to recognize that. I do think Alabama Association of Realtors, if I've got the case name right, is, I thought, quite a good example of authorizing the CDC to address the spreading of disease. Does that cover regulation of landlord-tenant relationships? Seems a little difficult to make that leap according to the court. And that just seems kind of intuitive to me. But I suppose that's all to say that maybe the devil's in the details about just the application in a particular case, how clear is clear enough, and that sort of thing.
The real debate right now seems to be whether it's a substantive canon or rather it's just a doctrine that is kind of consistent with the notion that we take into account context whenever we're interpreting statutes. And the delta between those kind of two disputing conceptions of the major questions doctrine is, I think, the clear statement rule. Whereas if you view this just as a part of statutory interpretation, then you're still looking for the best interpretation of the statute. What Justice Barrett lays out in her separate opinion is, if we're treating this as a substantive canon and we're saying there has to be a clear statement rule, the courts could perhaps choose a reading of the statute that is not the best reading, but there's no clear statement. So I think that is the delta between the two conceptions of the doctrine. And I wonder how much work that delta is actually doing. We have clear statement rules in a lot of areas of the law. I think clear statement rules are enforced perhaps with some vigor in the context of sovereign immunity. But for example, the federalism canon purports to have a clear statement rule associated with it. And despite me raising that argument over and over again, no one has ever said, we're going to interpret this according to the federalism canon. There's a lack of a clear statement. So I actually wonder, I think it's very interesting and academic, the distinction between a substantive canon and whether it's just part of the statutory interpretation process. But I don't know practically that it's going to change the outcome in a lot of cases, depending on where you slot it.
That's what put, if I could just add one thing, one observation is, at least as I read the major questions cases, if you look at, say, the major questions cases and some of the constitutional avoidance cases, to me, the major questions cases are quite natural readings of the statutes when you kind of look at the big ones. I think more people would say or acknowledge that the constitutional avoidance cases, the court is perhaps doing a bit more work to avoid a constitutional problem, which goes back to Matt's delta question. I think the delta between, say, what the statute most naturally reads and where the court has to maybe end up to avoid a big constitutional question or problem is maybe bigger in the avoidance cases. So I kind of see a distinction there.
And just from a theoretical perspective, do we think that if the non-delegation doctrine is more invigorated, do we think there's going to be more major questions, or do we think that the lines of arguments are going to shift more toward, should the agency be doing this to begin with?
I tend to think that you'll probably continue to have assertions of both, but I think that the notion that the major questions doctrine is kind of rooted in separation of powers and is carrying kind of more of the constitutional avoidance work could kind of be diminished if we have a reinvigorated non-delegation doctrine. So I think you could see the major questions doctrine moving more towards Justice Barrett's conception if it's not having to do the work of what is effectively an unenforced non-delegation doctrine right now.
Right, because the last time that the Supreme Court's actually held a statute unconstitutional for the non-delegation was Schechter in the 40s, right?
Yes, it's been a while.
So we've developed various tools to try and get the statutory meeting in the meantime, perhaps. Excellent. Well, I appreciate you guys coming on and having this great conversation. It's been a pleasure. We wish you the best as you go forward with your states. Let's do this again sometime.
Absolutely. Thank you, Jeff. Thank you, Matt. This was a real joy.
Thank you both. This was a lot of fun.
Scott, Matt, and Jeff, thanks for joining me today. This has been a very interesting conversation, and I'm sure our listeners enjoyed your insights. And thank you to our audience members for tuning in. Remember to subscribe to this podcast on whatever platform you choose, and we look forward to having you join us next time.
Copyright Troutman Pepperlock, LLP. These recorded materials are designed for educational purposes only. This podcast is not legal advice and does not create an attorney-client relationship. The views and opinions expressed in this podcast are solely those of the individual participants. Troutman does not make any representations or warranties, expressed or implied, regarding the contents of this podcast. Information on previous case results does not guarantee a similar future result. Users of this podcast may save and use the podcast only for personal or other non-commercial educational purposes. No other use, including without limitation, reproduction, retransmission, or editing of this podcast may be made without the prior written permission of Troutman Pepperlock. If you have any questions, please contact us at troutman.com.